What is the difference between an interview and an interrogation? Hi, this is Larry Kaye with ShadowAnyone.com and the creator of the Investigator's Ultimate Guide series, which is premium private investigator training from someone who's been there and done that. Largely, the terms interview and interrogation are kind of used interchangeably depending on what kind of slant the speaker wants to put on the event that happened. So if you're the one who is doing the interview, if you're talking to, say, a shoplifter, you're going to say, I interviewed the shoplifter and the shoplifter said this, admitted that. If you're defending the shoplifter, then you're more likely going to call it an interrogation, and you're going to paint it in that kind of color or those strokes to say things like, my client was in there alone. They didn't have anyone else with them. They were being interrogated by this person who does this every day, who is being tricky and trying to get them to admit things that they didn't do. The same exact event described two different ways. Interview has that softer, more reasonable tone to it, and interrogation brings to mind these ideas of yelling and pounding the fist on the table and shining a light in their eyes. So, which one is accurate, which one is really the case? Now, personally, what I like to conduct are interviews. I've always referred to the things I do as interviews, whether it's dealing with a shoplifter back in my loss prevention days, other people who've been accused of crimes later as a private investigator, even witness interviews, things like that. They saw an auto accident, or maybe they know where somebody is that I'm looking for, skip tracing. To me, I always do interviews. That's the phrase I like. And I think that accurately represents what I do. Anybody that would see or hear my interview after the fact would reasonably call it an interview. There's no yelling, there's no threatening, nothing like that. However, this is because I'm a private citizen. I am not a police officer, but police officers are held to a different standard with this term of interrogation and interview. So this has been actually set out by the U.S. Supreme Court in South Dakota v. Neville. And the Supreme Court, the U.S. Supreme Court, has said that an interrogation is any behavior by police, quote, that the police should know are reasonably likely to elicit an incriminating response from the suspect. Um, so now, if you look at the exact same thing that I do, and that's okay, so that's not just even asking questions. Asking questions, did you do it? Where is the stolen merchandise? Things like that. Clearly, that falls into the Supreme Court's definition of interrogation for police officers. But it can go beyond that to things like maybe looking at like a staged lineup, using that as a method of getting out the information, the admission of guilt or incriminating information. Um, Even things like minimizing the seriousness of the crime or offering the suspect excuses, all those types of things. If you say to the suspect, "Oh," if a police officer says, "It's just a little bit of weed. It's not a big deal. If let me see. Tell me where it is, and we can try to write you a citation, and you can walk away." That is technically an interrogation because it's something that the officer reasonably expects is going to elicit an admission of guilt. For me as a private citizen, and this falls into people who do loss prevention, private investigators, security guards, fraud investigators, bank investigators, things like that. That level of deception is permissible most of the time. I'm not going to speak to matters of law because I'm not an attorney. You need to talk to an attorney if you have questions of law. But we use deception all the time, and we use these elements that the Supreme Court has specifically said when police use it, it's an interrogation because of that definition of trying to elicit a incriminating remark. But we use them all the time, and they are not by definitions then an interrogation, but it is an interview. Uh, I would say, are you doing interrogations or are you doing interviews? You should be doing interviews, and I mean that in the context of this softer, gentler type of thing. I don't think there's any room for you to be threatening, to be yelling, to be out of line. And here's two key things I want you to take away when it comes to interviews that you're conducting, especially if you're a private citizen like myself or loss prevention security, those types of things. Number one, when you go into an interview, know before you go in what's the one key thing you can get out that you want to get out. If you know, okay, if I could only get one piece of information from this interview, this is the piece of information I want. Know what that is going in. It may be that admission of guilt. It may be that you need an address for somebody you're looking for. It could be a variety of things. You may just need the person to admit that they were at the scene of the accident. You may be able to get a lot more information, but know the one key thing you need if you could only get one thing before you go into that interview. The number two thing I would say about what you're doing is, even though you may not be held to this standard of interrogation where it's called an interrogation for a police officer trying to elicit that incriminating response, you will be judged on your interview. So be reasonable. You probably are going to have audio recordings of it, maybe even video. Certainly, in hindsight, people are going to judge you about that. It could be a defense attorney if you're working for the prosecution. If you're working for, say, loss prevention or bank fraud, you do an interview. The defense attorney is going to really look at how you behaved, what you said, the threats or promises that you made. So you have to keep it so reasonable, and you have to be honorable about it. When this interview comes to the light of day to people outside the room, you want to make sure everybody can see that you behaved honorably about it. The other thing is, your client is going to know what happened in that interview room, what you said, the threats or promises you made, that type of thing. And you should know your clients well enough to know what they deem acceptable or unacceptable, especially when you're dealing with law firms. Some lawyers will have different standards than others. You may have an attorney client, a law firm you work for, and they say you can never offer mitigating excuses. You can never tell them that it's not that big a deal, because it is. That may not be the law, but that's what their requirement is, the client who's paying you the money. Other law firm attorneys, they don't mind anything you do that's legal. They can use it and they accept it that way. There's a broad spectrum of what your clients will accept. Know that before you go into interviews as well. No matter what you do, remain honorable. Remember that what you do will come to the light of day sometime, so don't step out of line. This is Larry Kaye with ShadowAnyone.com. Remember, do the right thing, even if it's the hard thing.